Afternoon. This meeting, what is this? This Monday, January 26th meeting of the Civil Law Subcommittee of Courts of Justice will come to order. I'm hearing my echo.
Yeah, you're right. I mean,
you got it fixed.
It's not good when you're echoing. I'm hearing you twice.
All right, members will...
Making it even worse.
Making it worse. Members will indicate their presence on the electronic voting board. All right. A quorum is present. So we're ready to conduct some business. Let's see. Delegate Griffin, so House Bill 202, Delegate Griffin, we have an identical bill that's sitting in general laws. It needs to go through the referral process and whatever. So can I get a motion to take House Bill 202 by for the day? So moved. It's been moved and seconded. House Bill 202 go by for the day. As many as fair that motion will say aye. Aye. Those opposed? All right, that bill is by for the day. Thank you, Delegate Griffin. There was a time when I would have just made you sit there for the whole meeting to do that, but this is the new, nicer Delegate Simon. All right, Delegate Helmer. You've got House Bill 273.
Thank you, Mr. Chair, members of the subcommittee. House Bill 273 is a bill we've worked closely with law enforcement on. It is a bill that sets clear, common sense expectations for life-saving care when a law enforcement officer encounters an individual that is suffering from a serious bodily injury or life-threatening condition. It also balances that by saying that, one, you have a duty to render aid, two, if you render aid in a critical moment and you are doing so in good faith, that you are protected from liability except for gross negligence or willful misconduct. It's, the situations you can imagine it dealing with are everything from a law enforcement involved shooting in which there is that duty to render aid, or an instance in which a law enforcement officer is first to respond. Lastly, it does ask DCGS to establish, this was a request from law enforcement, to establish some training standards for first aid and medical training, so to make sure we have uniformity across the Commonwealth of Virginia. I stand at the pleasure of the subcommittee, Mr. Chair.
All right. Any questions from members of the subcommittee? Delegate Ballard.
Thank you, Mr. Chairman. Question, Delegate Helmner. When I first read this, what jumped into my mind was qualified immunity. Can you just kind of tell me what the interplay is between this bill and what you're trying to do, and then what we generally refer to as qualified immunity?
Thank you, Mr. Chair. I'd answer the delegate that this doesn't take a position on qualified immunity anyway. It actually just articulates a specific duty to render aid in a specific set of limited circumstances, and then just establishes that absence gross negligence or willful misconduct, the officer is protected for rendering life-saving first aid.
And brief follow-up, Mr. Chairman.
Delegate Ballard.
And it's probably a question for counsel. So when we talk about gross negligence and willful misconduct, where's the definition? Where are the definitions? What's that refer to?
So, Mr. Chair, Delegate Ballard, we don't have that defined, but that is the phrase that we always use when we talk about the civil immunity provisions. My understanding of qualified immunity is that if you are grossly negligent or you willfully do something wrong, that qualified immunity wouldn't protect a law enforcement officer anyway.
Thank you, Mr. Chairman.
All right. Delegate Sullivan.
Mr. Chair, thank you. Question for the patron?
Yes?
Yeah.
Go ahead. Delegate Sullivan.
Yeah, okay. Delegate Hummer, I got to confess, when I saw your bill, I was surprised that we didn't already have a duty on law enforcement. Like this have there been episodes, or is there a problem we're trying to solve? I candidly have always assumed that a law enforcement officer driving past the scene of an accident would have a duty to stop and help.
Thank you, Mr. Chair. I'd answer the delegate that we don't specifically articulate that in code, and I think in most instances an officer who sees this would actually stop. I think one of the things we're dealing with, right, is an officer involved shooting, right, where if you are involved in an officer involved shooting, that you do have to render aid in that case. We're just making it very clear. There are other instances. So yes, we are explicitly articulating in code that there is a duty to render aid. We worked with the sheriffs and the police to just make sure that we were not being so broad in our approach to it that it caught things in that we wouldn't expect law enforcement officers to do. And so it's meant to be narrowly tailored, but to articulate in a clear way exactly that there is this responsibility to do this. And then also the piece that's important is like we actually don't have a uniform set of regulations or standards about training, and so that'll be helpful in terms of the enactment as well.
Well, thank you. And I think that will be helpful. Obviously, I'm going to vote for the bill. It seems to me this codifies something that we could all reasonably expect from our law enforcement anyway. I'd be surprised if law enforcement had any problem with this bill. Thank you. Thank you for bringing it.
So I would just, on that question for council, I think, if I'm not correct, there is in some context, we already have a duty that's articulated in some parts of the code. I think, if I'm not mistaken, 19.2, 83.6, there's some liability for a failure to intervene. So it doesn't create an affirmative duty to intervene, but there are sanctions, not sanctions, but there are penalties for failure to intervene. Am I correct on that?
That's correct.
Okay, so it's not, we're not creating this out of cloth. And in fact, they already have, they can be, they can suffer consequences from failing to intervene, but we don't have currently the immunity protections that Delegate Helmer's bill would provide, nor do we have the training requirements. So in some ways, I think all these bills are pro-law enforcement, but I think this is certainly, goes beyond what we have on the books now and actually probably helps to standardize it and provide some immunity that law enforcement officers don't already have. Delegate Ballard, do you have another question?
I do, Mr. Chairman. So Delegate Helmer, kind of different lines. So to use your example, when you're talking about officer-involved shootings, so when you say that, I'm picturing in my mind, there's an officer-involved shooting, you're saying then with this bill, there's an affirmative duty to other officers who are on scene to intervene and administer life-saving measures as long as they can be rendered without endangering the officer himself, the person, or others. Am I understanding that correctly?
Mr. Chair, I'd answer that correctly. It would be true of the officer themselves as well, right? So long as they were, again, to your point, rendered without endangering himself, the person, or others.
Thank you, Delegate Ballard. And again, I would say that's exactly the scenario that 19.2, 386, or 83.6 already covers. It says that law enforcement officer, just real quick for everybody who thinks we're making things up new, this is already in the code. A law enforcement who, while in the performance of his official duties, witnesses another law enforcement engaging or attempting to engage in use of excessive force against another person shall intervene when such intervention is feasible to end the use of excessive force or attempted use of excessive force or to further prevent it, and also to prevent any personal injury as a result. So you've got a duty already to intervene, and then also this duty is an additional one to render aid more explicitly. Any further questions from members of the subcommittee? Anyone in the audience wishing to speak in favor of the bill, please come forward. Anyone wishing to speak in opposition to the bill, please come forward.
Mr. Chairman, Bill Carrico with Virginia State Police Association. As we look at this bill, we see it as another attempt at qualified immunity where there's no definition to willful misconduct. It's going to create more and more lawsuits because it's not defined, it's not shown anywhere in the code as to how it would apply. I have our legal counsel with us. We've been looking at these bills. This bill got flagged for us because we feel that this is going to create more and more issues, and it's going to create more and more problems with us to recruit and retain troopers for the Virginia State Police. And I'll yield to my counsel.
Mr. Chair, members of the subcommittee, David Ostrinkel, Virginia State Police Association. The key problem that we see with the bill is that willful misconduct is an undefined term. It's going to be a lesser standard, which will allow essentially the promise of immunity for rendering aid to be ineffective in terms of most pleadings will plead the lesser standard of willful misconduct, and in any close calls, the reality is going to be that a lawsuit's going to be filed, notwithstanding the fact that somebody tried to take some measure to provide aid. And it's going to force the issue of objective reasonableness to the jury, where essentially the plaintiff in any case is going to plead that the officer could have done more. And then secondarily, while there is a mandate for some training, there's not a statewide standard that will allow officers to have a clear guidance with respect to what instances they must and shall take action to render aid. Thank you.
So we get this a lot, right? And we get this effort to sort of define every term and every bill, and we post it by sentence. I mean, sometimes you have to use the plain language. You're aware that the term willful misconduct appears in the code of Virginia 156 times?
That's correct. Yeah, in this context, it should be defined. It should be defined by a standardized policy that would allow officers.
How many requires a standardized policy?
It requires training. It doesn't require a standardized policy that would allow officers to know the context in which they can operate and avoid litigation. Thank you.
Sorry, my mic
Yeah,
was
Mr. Chair, my question is for council as well. I'm unclear with respect to what the concern is. I'm under the belief that if an officer is involved and someone is hurt, that this is something they would be doing anyway. Is that accurate?
There are instances where there may be other priorities that would take precedence and require that an officer not immediately render aid. Those would be instances where there may be some question whether or not it should have been done, and what it's going to result in is litigation.
Clarify, what do you mean it should have been?
Delegate Keys-Gamarra.
Sorry.
Follow-up question?
Well, I
Go
didn't
ahead.
understand what he
Go
said.
ahead. Go ahead. I just wanted to,
I appreciate it, Mr. Chair.
you can ask your next
Sorry.
question.
I was just asking for clarification of what he was saying. It wasn't I had a follow-up question. This isn't it. But my follow-up is now because of what he said. He said it should not have been done, and I'm not clear on what that means.
I said there are instances where there will be question as to whether aid should have been provided at a certain point in time. There are instances where there are priorities for police officers to not render aid and to take other action. For example, to secure a scene or to secure a suspect. There may be question as to the timing of that under the objective reasonableness standard. In those types of instances, the default is going to be civil litigation.
Any further questions, Delegate Keys-Gamarra?
I do.
Okay, Delegate Keys-Gamarra.
Thank you, Mr. Chair. Are you of the belief that the police officer would be held to the same standard as someone trained in providing medical care?
Well, they're going to be held to the standard of their training, and they are indeed required a certain level of first aid and CPR through DCGS.
Thank you, Mr.
All right, Delegate Sullivan.
Thank you, Mr. Chair. Sir, what happens now? Since there is no statute, what happens now if, I'll try to conjure an example, officer comes upon a scene, someone's been injured, and the officer has to make a decision between helping the person who's been injured and taking action against other people to secure the scene or whatever. What rules govern that now?
It would likely be gross negligence. And with the inclusion of willful misconduct, which would be a lesser standard, plaintiffs are going to gravitate towards a lesser standard.
So, follow up?
Delegate Sullivan.
Your view is that willful misconduct is a lesser standard than gross negligence?
Yes.
Thank you, Mr. Chair.
Delegate Reeser.
Thank you, Mr. Chair. And so in the case of civil litigation, what happens?
I'm not sure I'm clear on your question.
It goes to a trier of fact, correct?
Yes.
A judge would have to make a determination, or perhaps a jury, as to whether that standard was met. So it's not an automatic finding against a law enforcement officer, correct?
That's correct.
And that's the same standard that all civil litigation is met with after an initial motion to dismiss or demur.
The problem here in this legislation is that there's not a clear standard by which the officer should meet his or her obligation to have provided care in a particular circumstance.
Last question.
The training is provided, but the standard's not there.
Delegate Reeser.
Are you saying that willful misconduct is an unclear standard?
Yes. In its application here, yes. It's
Understood.
Anyone else in the audience wish to speak in favor or against the bill? Anyone online?
Is there anyone online? Do we have folks online for this bill? Let's see, who we have. Sorry. I'm lightly staffed today because of the weather. You can tell my poor performance. Usually Andre makes me look better than this. All right, we are on House Bill, what number? 270. And we've got Elizabeth Hobbs from the Virginia Sheriff's Association. Ms. Hobbs.
Thank you, Mr. Chairman, members of the committee. I'm Elizabeth Hobbs with the Virginia Sheriff's Association. The sheriffs support this bill as a statement of what they consider to already be their duty and the obligations that they're already performing under. Thank you.
Thank you. All right. All right. Any, no one else in the audience wishing to be heard on this bill? Any further questions from members of the subcommittee? We've talked this one pretty well. It's been moved. Delegate Reeser moves to report. Delegate Keys-Gamarra seconds.
Mr. Chair, can I just
Speaking to the bill, Delegate Ballard.
Thank you, Mr. Chair. Just briefly speaking to the bill. So when I first read this, what went in my mind was it was a creative attempt to kind of subvert qualified immunity. That was where my head went initially. And then I started thinking about it, and I kind of circled back around to, as Delegate Sullivan said, I'm surprised we already don't do this and it's not codified. I'm unmoved by the argument from counsel for Virginia State Police about gross negligent and willful misconduct and all that. That's littered throughout the code, and I think everyone's in agreement with that. But I'm going to vote no just to flag it so we can have a broader discussion with other members of the full courts. Doesn't mean I'll always be a no. Thank you, Mr. Chairman.
Thank you. All right. With that, the clerk will open the roll. Members will cast their votes. The clerk will close the roll. Bill reports on a vote of 7-2.
Thank you, Mr. Chair, members of the subcommittee.
All right. Next up, I think we had Delegate McAuliffe here. The thing I love about this committee, we shift gears rapidly.
Good afternoon, Mr. Chairman, members of the subcommittee.
So what's your very exciting bill, Delegate McAuliffe?
My hopefully considerably less exciting bill is 510. And our goal here today is to pass a bill that will protect seniors and their estates from abuse and theft by ensuring their family members and their successors can obtain information from any agent that is acting under a durable POA about financial transactions conducted on behalf of the loved one. The problem that we're trying to address is essentially there are some instances in which a blanket non-disclosure provision that could prevent a person's family members or successors from obtaining information about various financial transactions taken by an agent at that family member's behest. The concern is this could be abused by that agent, acting under a legitimate power of attorney, but it could be used to conceal financial mismanagement, theft, or other misdeeds. So what this bill proposes to do is make a code change to 64.2-1612, which would require any principal to affirmatively sign or initial an express statement in the power of attorney that they intend to relieve their agent from the fiduciary duty to disclose to their statutorily defined family members and successors that the provision reflects the principal's wishes regardless of whether such provision is in the principal's best interests if they later become incapacitated. I'll add one more thing to this, which is if somebody, as in the case where they are intentionally cutting out family members, they're explicitly wants to cut specific family members or entirety of their family out of any sort of decision-making process in their will, they can still do so. The problem is it's currently the default state, whereas this would require it to be expressly done. And with that, I yield to the committee for questions, concerns, and I hope it be the will of the subcommittee to help me get this done.
Mr. Chairman.
Questions from members of the subcommittee. Delegate Kilgore, followed by Delegate Keys-Gamarra.
I do a lot of these power of attorneys, and one thing I was going to ask on the waiver, when the principal's signing the waiver, does that have to be in front of a notary public, just like the power of attorney would be?
You need to phone a friend?
I do.
I mean, there's formality requirements with the power of attorney. I was just making sure that those same formality requirements would be with the waiver.
Mr. Chairman, members of the subcommittee, Eric Link on behalf of the Virginia Bar Association. Delegate Kilgore, it's not expressly said in here, but I think that and if you want to have the power of attorney, you have to have the notary.
Right.
Yeah. So I guess my question back to you is do we want to is this an opportunity for a friendly amendment?
Mr. Chairman, I would think that if your goal is to protect the principal, if your goal is to make sure that something nefarious is not happening, that you would have it signed in front of a notary, that person, because you could just, if it's not signed in front of a notary, the power of attorney could just take it out and said, yeah, mom or dad or uncle signed this, at the house and I was there, et cetera. So, I'm not.
I got you. If I understand correctly, I think we were trying to figure out the practical nature of this, right? I think when I read the bill, I sort of envisioned that you're sitting there executing a power of attorney and there's check boxes to be filled out, or there's certain powers. And if you're going to say, if you're going to put in your boilerplate, because you get a client that says, listen, I want my power to have maximum authority, maximum latitude, everything that's waivable, waive it. So you put in the boilerplate language that says they're waived from their duty to disclose. That particular provision has to be set out and has to have a place for the person to initial and sign. And the thought was that that's going to be happening all at the same time that the power of attorney is initially being executed. Delegate Kilgore's raising the specter that a regular power of attorney is signed, and then somebody adds this provision later in pen and ink, and they sign it and initial it, and now there's no notary around, there's no witnesses, there's nobody else, but they've technically met the requirements of the statute by just hand editing the power of attorney. So how do we overcome that potential? Counsel, you have an idea about that? You're nodding at me.
Yes, Mr. Chair. So if we do want to add language to that 64.2-1603, which is the execution of power of attorney section, it looks like the sentence regarding the conscious presence is in this bill. The sentence that is not in this bill that we could potentially add is a signature on a power of attorney is presumed to be genuine if the principal acknowledges the signature before a notary public or other individual authorized by law to take acknowledgments. We could play with the language a little bit so it fits here, but if that's what you want to do, there's precedent for it.
I don't mean to be any harm. I think it's a great.
Could you raise your microphone on, Doug? For the people listening at home.
Yeah.
We can hear you, but.
Yeah, I'm not meaning to be any harm, but I think this is another protection that we could add on top of make sure that everybody's protected. So I would move that we adopt the amendment and ask council just to draw something up before the full committee.
Is there a second?
Second.
All right, it's moved to second. Doug Carney, do you want to speak to this issue, or do you have a different concern?
No, it's about this issue. The way I read the amendment to this language was...
Doug Carney, your microphone's not on.
Sorry. No, it's about this issue. The way I read this additional language to the code is that it's a provision within the power of attorney. And so if the power of attorney is signed, witnessed, has a notary, you're good to go. My concern with adding that language would be, let's say the disclosures on page 3 of 5, do we have to have a notary sign page 3 and page 5 or just page 5? And so I think it creates more confusion than just making sure that this disclosure is included in the power of attorney, which is what it already says.
And my issue is basically not what covered in the initial power of attorney, because I would put it in the initial power of attorney, but I'm talking about somebody that comes back later and said, hey, we forgot this, or, I did a power of attorney for somebody last year, and they come back and say, hey, we want this included. I just want to make sure that had a notary, that was signed in front of a notary.
So council has an idea for that too.
Yeah, so Mr. Chair, when I said that I was going to play with the language, I was going to make it specific to the disclosure. So it wouldn't be the entire power of attorney would need to be re-notarized. It would just be the disclosure provision. So it would read more of a signature on a disclosure drafted pursuant to subsection J, blah, 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 blah. Does that make sense? So I would try to make it as narrow as possible so that it wouldn't have to re-notarize every single power of attorney.
Yeah, and I think if the language was as you're playing with it, saying essentially if this language was not included in the originally notarized power of attorney, that it would need this additional language. And so in those circumstances. Yeah. All right. Everybody understand the amendment and concept that we're asking for to have done before we take this bill up in full? All right, so it's been moved and properly seconded that we amend the bill as described in this conversation that council will somehow remember. So those in favor of that motion will say aye. Aye. Those opposed? All right, that amendment is agreed to. Any further questions from members of the subcommittee?
Move to report.
Let's see, we have to hear from the public first. Is there anybody in the public wishing to speak in favor of the bill? Given where it's going, I see that you wisely said that. Anybody wishing to speak in opposition to the bill? All right, seeing none.
Now I move to report.
It's been moved and seconded that the bill report as amended in concept. As many as favor of that motion will say aye. Aye. Those opposed? All right, the bill as amended in concept reports moves forward to full committee.
Do we do that?
Oh, we got to do that. You're right, never mind. I'm just rolling along today. All right, the clerk will open the roll. The clerk will close the roll. Delegate Leftwich, just to flag it to make sure we don't forget to do this again at full committee. So bill reports with the amendment in concept 9-1. Delegate McAuliffe, we'll get together with you before full, make sure that the language looks good.
Thank you, Mr. Chairman. I thank the delegate for the amendment. Appreciate it.
All right, Delegate Cole and then Delegate McLaughlin. I see you there. I just don't want you to think you're being forgotten. But Delegate Cole, I think, was here first. Delegate Cole.
Thank you, Mr. Chair. Good afternoon, members of the committee. I have before you HB 73. HB 73 bill comes out of a second-year study, work done by the Commission on Youth. It was developed by a work group of 6 judges and 35 stakeholders. This legislation provides a technical clarification to the relief of custody process under Code 16.1-241. Currently, this section specifies that a parent may petition the court for relief, but it is silent on other legal caregivers. This bill adds the phrase other custodian after parent. While juvenile and domestic relation courts already hear these petitions from non-parent custodians under current practice, the code does not explicitly grant this jurisdictional authority. In addition to this technical fix, HB 73 adds language to the relief of custody statutes requiring any petitioning parent or custodian to cooperate with the local Department of Social Services during the initial investigation. Under the current law, a petitioner can refuse services intended to stabilize the home, making the entrance into foster care more common than it should be. By requiring cooperation, this bill would relief of custody with the same reasonable effort standard judges currently use in other custody transfers. The group of judges that reviewed the issue expressed the need for the code to require petitioners to cooperate with the local Department of Social Services in accessing services to prevent the breakup of the family. This bill is a recommendation from the Virginia Commission on Youth and is identical to Senate Bill 206, which has already passed the Senate courts unanimously. And the goal of this bill is to keep children out of foster care whenever possible and to encourage families that are struggling with their child to cooperate with their local Department of Social Services to receive the needed services. Also joining us online should be Will Egan from the Commission on Youth, who will be able to answer any questions that the committee may have.
All right. I will just say, as a matter of evidence, the jury's instructed not to give any weight to the Senate vote on this bill, right? We can totally disregard that. And suggest that we not mention those votes in future bill presentations. But anyway, Delegate Ballard, you have a question?
Yes, Mr. Chair. So to the patron or council, if you want to weigh in, I want to make sure I'm thinking about this correctly. So this could be the scenario where a parent has a child and is like, I can no longer care for this child and can get in front of the court. So that's already in code. It could be another scenario where another person defined in existing language can petition the court to remove a child from a parent's custody. And then what you're doing is you're adding that language about guardian, I think is what your language was.
Legal guardian.
Legal guardian.
Whoever has custodian.
And so I guess my ultimate question is the way I'm thinking, I do this in West Virginia too, and they call it a motion to intervene. Is this basically what I'm thinking of as a motion to intervene by a legal guardian?
At this point, I'll yield to either Will Egan, who's online, or to legal.
Getting the shaking head in the other direction from council. So let's go to Mr. Egan, see if he has any thoughts about that question. Mr. Egan, if you could identify yourself and if you can answer the question, that'd be great.
Sure, Mr. Chairman and Delegate Ballard, Will Egan from the Virginia Commission on Youth. Here today to answer any questions you may have. Delegate Ballard, your question is about whether or not this would be something like similar to intervene. This would be when a custodian, so someone who has current custody of a young person, wants to relinquish their custody. So it's a little bit different than how I heard you describe it. Hope that answers your question.
Brief follow, Mr. Chair.
Delegate Ballard.
So is it only the situation for relinquishments?
Mr. Egan?
So, Mr. Chairman, Delegate Ballard, in current code, and that jurisdictional statute, it just references parents. And the other relief of custody statutes, it mentions parents and custodians. So this would be aligning the jurisdictional statute with the current practice. So current practice, a grandparent with custody could petition relief of custody, and they currently do under current Virginia law. So this just aligns what practically happens with what the code should say according to this relief of custody work group that met.
Thank you. Delegate Lafwich.
Thank you, Mr. Chair. So I can read, and I see where it says relief of care and custody, but I just want to make sure, I want to hear somebody say it, it does not apply to termination of parental rights in any way, shape, or form.
Counsel?
That's correct, Mr. Chair. Those sections are not in the bill.
Okay, thank you.
All right. All right, any other questions from members of the subcommittee? All right, anyone wishing to speak in favor of the bill, please come forward. Anyone in opposition? Anyone with some more information that they're dying to give me? Come on up. Please identify yourself.
Good afternoon, Delegate Simon. Sandra Carrison, Office of the Executive Secretary, Supreme Court of Virginia. I just wanted to clarify one point. It was just last raised, and Willie can obviously online can speak to this, but so that the committee has full information, the statute already provides, and this is not changed in any form by the delegates' bill, that a parent can file for relief of custody and seek permanent relief of custody with termination of parental rights. That's already in the statute and has been for years. It does not apply to custodians that were just talked about, the guardians. It speaks to a parent's parental rights, but just because that point about termination of parental rights was just addressed, I wanted to clarify that point for a point of information.
And that's because custodians don't have any parental rights, right? I mean, all they have is the right of custody. That's the only thing that they could terminate through a process like this.
Exactly, and the court has no position on the bill. Is my best point at this point in time.
Got it. Thank you. All right, Mr. Egan, do you have anything you wanted to add as far as testimony goes, or are you just here to answer questions?
Mr. Chair, just here to answer questions. We support the bill.
All right. So one more time, last call for anyone wishing to speak in support or against. All right, seeing none. It's been moved and seconded that the bill report. The clerk will open the roll. Members will cast their votes. Sullivan, do you want to vote? The clerk will close the roll. The bill revotes 10-0. Thank you.
Thank you, Mr. Chair, members of the committee.
Delegate McLaughlin.
Thank you, Mr. Chair. Committee, I have House Bill 350. This would actually just make some changes to the code 8.01-341 relating to jury service. We'd like to add the fire marshals to the list of those that would be exempt from jury service. You know, fire marshals are unique in that they typically just work for the fire department, but increasingly here in the Commonwealth, they are becoming certified law enforcement officers, and it makes it necessary for them to conduct investigations and enforcement. Fire marshals are often working detailed criminal cases, conducting investigations, and that gives them information and details in certain situations that would make it inappropriate for them to serve on jury duty. And we really want our juries to be as impartial as possible. So in order to do this, I think adding our fire marshals would be a good step in protecting the integrity of our juries.
I have a question. So what is the difference between being automatically exempt under 341 and just other exemptions? Maybe this is a question for counsel, but I mean, because you said certain circumstances it would be inappropriate for them to serve. I mean, couldn't they just say that in those circumstances? Why do they need to be automatically exempted?
I'll take an attempt at that.
Okay.
Mr. Chairman. So, just it's same thing as we look at our law enforcement officers, they are already exempt. And that's because they're doing the investigations. They're coming up with all the different things. They're seeing all the things that come on behind the scenes. They see all the evidence and everything. Counsel, I don't know if you would agree with me, but I would say that, in the capacity that some of our fire marshals are serving, they're getting the same information. And that would make it very difficult for them to be impartial.
Yes, Mr. Chair, the only thing I would add is that 801-341.1 is the exemptions from jury service upon request. So you would be exempt if you request it, but it wouldn't be automatic. And they enumerate several different individuals there. I think the closest thing would be any person who is the only person performing services for a political subdivision as a firefighter, but state marshals aren't listed in this section.
So we already exempt firefighters as permissive. They can request it. State fire marshals actually aren't listed in either one. So they'd actually have to demonstrate some sort of a reason. All right. So the question is, maybe if there's a question at all, is my concern, Doug, is the Christmas tree effect. I think last year we had a clerks of the court. Now we're having fire marshals. Who's going to come next year? How long is this list of folks going to be? And so I don't know. Is there a problem? Are fire marshals being called to jury duty and not able to get out of it? That's the question I'm wondering about.
Well, Mr. Chairman, this did come up and this was brought to us. And I do have the state fire marshal here that maybe he could answer this a little bit more explicitly. I believe Billy's still here.
Yep. Yes, sir.
Yes, sir. What was your question?
Is this a problem? What's the problem we're trying to fix? Are there a lot of fire marshals that are getting called for jury duty that are not able to get out of it?
So we've seen in some localities, day-to-day, we're the AHJ for 63 of the 95 counties in Virginia that haven't legally adopted the code. So as you can imagine, it's a smorgasbord across the state. We have run into it a couple times where local court systems aren't sure. But as counsel mentioned, we have, for the most part, been able to reach out ahead of time and explain what we do, and a lot of times it will be exempt.
All right, thank you. All right, we got some questions from members of the subcommittee, starting with Delegate Leftwich.
Thank you, Mr. Chair. So I'm looking at, I just want some clarification, because on line 22, we're adding language, and any other law enforcement officer is defined in 65.2-102. And as I read that section, we're talking about auxiliary officers, reserve officers. I mean, are those folks already exempt, or are we really expanding the scope that much? Yes.
Yeah, I mean, it sounds like a fairly large expansion. I think maybe this was meant to sort of be a belt and suspenders for the fire marshal, since they're considered law enforcement officers now, but I think that may be doing more work than was intended by the patron.
Mr. Chairman, our intention was just to add our fire marshals.
All right. So I get a motion to strike the changes on lines 22 and 23. It's been moved and second that we strike the changes to the bill, so add back in and strike the other new language. As many as favor that motion will say aye. Aye. Those opposed? All right. So now we have a line amendment. So now we're down to the question of whether the state fire marshals themselves ought to be added to this Christmas tree or not. Delegate Keys-Gamarra.
Thank you, Mr. Chair. Does anybody have can they give me an explanation of how these fire marshals are put into place? It says on line 27 that they're often appointed. I'm unclear as to whether this is a full-time thing or whether it's like we have volunteer firefighters sometimes and people kind of are available when they need. I don't understand their role. It would help, I think, if I had some clarification.
Mr. Chairman. So I will try to answer that for you, and I do have my expert still here with me, but your fire marshals are a full-time position. Mm-hmm. They're not just a volunteer position.
Did he?
Yes, ma'am. Just repeat your question.
If I may, Mr. Chair. I was trying to get a greater understanding of how the fire marshal role is conducted in the Commonwealth. And it says on line 27 that they can be appointed. I don't know whether that is for a just a specific period of time, or if they are just available. I'm unfamiliar. This is new territory for me.
Yes, ma'am. So the Commonwealth State Fire Marshals, we're all full-time. You do have local fire marshals in those other jurisdictions. It is a possibility that they could be a volunteer, but you would be looking at the difference between Title IX and Title 27. And if you read the bill language here, 2730, that's what covers the state fire marshal side of it.
Follow up, Mr. Chair.
Delegate Keys-Gamarra.
So you said those that would be volunteers are not covered by this?
Any volunteer fire marshal would be recognized by a locality, and they would not be considered a state fire marshal.
Okay, thank you.
Okay. And I'm a little, now you mentioned that section, I just make sure this syntax is correct, because so this is, like I said, we have two ases, and I'm not sure how they work together. So the state fire marshal as directed, as described in 9.1206, that's obvious. The state fire marshal will be exempt. And any officer as appointed as a fire marshal, do we need both ases, or are there any officer appointed as a fire marshal pursuant to Chapter 3, 2730? Or is there a reason it's phrased that way that I'm missing?
Mr. Chair, this would be different than the state fire marshal, because 2730 talks about the appointment process. So any officer who shall be called a fire marshal may be appointed, and these are the locality ones, so may be appointed for each county, city, or town by the governing body. Whenever in the opinion of such body, the appointment shall be deemed expedient. So it is a separate, it's not the state fire marshal, and these locality fire marshals are different.
Yeah, no, my question is sillier than that. There's two ases. There's an as before the word appointed, and there's an as after the word appointed. And do we need the as in both
probably
cases?
not. No, that's probably just an error we can
Okay,
strike.
we can just fix that typographically later without an amendment. Okay.
Overthinking.
I was wondering if there's a missing word in between or something like that. I'm not trying to be too difficult. All right. All right. Anybody else wishing to speak in favor of the bill in the audience? Anyone wishing to speak in opposition to the bill? All right. Committee operates by motion.
Move to report as amended.
Oh, wait, we have, well, before if you'll withdraw your motion for just a second, Delegate Keys-Gamarra.
If I may, and my expert went and sat down.
Hopefully.
Based on the language that was just read, I believe your answer to me was that those appointed would not be covered? It looks like they are.
The way that line 11 reads, that would cover the local fire marshals as well as the state fire marshals. That also includes any fire investigators as well.
Okay. And some of those would include, follow up, Mr. Chair.
Delegate Keys-Gamarra.
Okay. Some of those would include the volunteers that you're talking about.
If they are appointed pursuant to Title 27, correct.
Thank you.
Yes, ma'am.
All right. I spent a lot of time on a relatively easy bill. Delegate Maldonado, do you have a motion?
Yes, Mr. Chair, I move to report the bill as amended.
All right, it's been moved and seconded that the bill report as amended. Any further discussion from members of the subcommittee? Seeing none, the clerk will open the roll. Members will cast their votes. I'm going to be an anti-Christmas tree, but I think otherwise it's probably a good bill. So the clerk will close the roll. Bill reports 9-1. Thank you, Delegate McLaughlin. All right, Delegate Carr, you've been sitting there in the back. Did you just get here? Who got here first? You or Delegate Hamilton? Sorry? That's okay. Delegate, I'm going to go with the Vice Chair of Appropriations, if you don't mind. Delegate Carr.
Thank you, Mr. Chairman. I would like to move the committee substitute to HB 803.
You can't do that, but we can get somebody on here to do it. Somebody want to move the substitute? It's been moved and seconded that we adopt the committee substitute. As many as favor that motion will say aye. Aye. Those opposed? All right, the substitute is now before us.
Thank you, Mr. Chairman. This conforms the bill to its Senate cognate and clarifies the process and requirements within the bill. The bill before you revisits last year's SB 123, including suggestions made by the Housing Commission. HB 803 helps homeowners perform repairs on their homes. Specifically, it helps homeowners in my district, where homes often abut the property line. In most cases, neighbors grant access to each other's property and communicate about the specifics. However, a stubborn neighbor can disrupt this harmony. Reasonable requests can be denied with no recourse for the homeowner in need of repairs, causing vital repairs to be neglected and deteriorating the structure. This legislation solves the problem by giving the owner of a property that needs repair the ability to petition the circuit court for permission to enter the adjoining property to make those exterior repairs. A petition to the court may be made only if it is impossible to perform such repairs without entering the adjoining property, and the person who owns the adjoining property denies the petitioning owner entry, or the person who owns the adjoining property put unreasonable conditions on entry. The petition and affidavit submitted to the court must explain what efforts the owner has made to obtain permission, why entry to the adjoining property is necessary, proof that the providers of the repairs are licensed and insured, among other pertinent details. Following a hearing, a court can grant permission. The homeowner must pay a bond and is expected to pay for any damages to the property. I believe this legislation strikes a balance between giving a venue for a reasonable request to be granted while not damaging property owners' rights.
Thank you, Delegate Carr. And it looks like the biggest differences between the substitute and the bill as introduced is we added a list of sort of 5-6 elements that need to be in the petition to show that you tried really hard to do this the nice way before you went to court. You're not just going straight to court, right, dragging your neighbor into court. And also give some specificity to try and limit to the maximum extent possible how intrusive the entry is. So it's just limited to what your specific purpose is. And then, of course, you have a copy of the petition. That seems to be the crux of the new language of the bill. Are there any questions from any members of the subcommittee? Delegate Ballard.
Thank you, Mr. Chairman. I think, is this the bill that you brought last year?
No, I did not bring this last year. It was brought over in the Senate.
Okay, I'm trying to remember how I voted on it.
Delegate Ballard, this is a bill that I think we've reported out of the House and a couple different occasions over the years. I don't know, some before you got here, some after you got here. And we got pulled off the House floor, I think, and was referred to the Housing Commission once. But it's been through all those processes and everything, been worked over and massaged.
Well, Mr. Chairman, if I may, so I guess my question, while I'm trying to remember how I voted on it, the bond issue, it doesn't specify the amount of bond. So is the bond equivalent to the value of the work to be done, or is the bond set by the court during that petition process? Do you have any idea?
I do not know.
Okay. Britt, do you have any idea?
Find that.
Mr. Chair, Delegate Ballard, I would think that based on the language, the court just would set it, and I don't think there's any sort of amount in here that it would be limited to, or, yeah, it's just the court setting it.
So it'd be within their discretion. Delegate Leftwich.
Thank you, Mr. Chair. I would note that setting the bond is permissive, not mandatory, which is concerning to me. And I'm also concerned about the servient estate's costs of defending an action, if it came to that.
Sure.
Delegate, did those just concerns? No, not. This is what it's designed to get at. Just these are the zero lot line things. You can't, you can avoid the court costs, and you can avoid going to court by being reasonable and being a good neighbor. These are really those situations where somebody's just unreasonably withholding their permission to do something that's absolutely necessary. But I hear you. Delegate Sullivan, did you say?
No, I'm fine.
Okay. Delegate Carr.
Mr. Chair, I was just going to say, I had one constituent brought this to me in terms of there's this much space between the houses, and the one house is right on the line. The other neighbor will not let her go around here and see what needs to be repaired on her side of the building, and will not give her permission to go there. So this is the kind of instance that brought this up.
All right. Anybody in the audience wishing to speak in favor of the bill? Anyone online wishing to speak in favor of the bill? No. Anybody in the audience wishing to speak in opposition to the bill? All right. The last words, Delegate Carr.
Hope the committee will look favorably upon this.
All right.
Make a lot of constituents happy.
So moved by Delegate Sullivan to report with substitute, with
Move to report the substitute.
the substitute, right, yep. It's been seconded by Delegate Keys-Gamarra. The clerk will open the roll. Legacy LIS is failing me. I was looking for Delegate Ballard's vote, but. All right, the clerk will close the roll. Bill reports 8-2. All right, thank you, Delegate Carr.
Thank you, Mr. Chairman, members of the committee.
Yeah, we just, yeah. All right, Delegate Hamilton. Which bill
thank
do you
you.
have here? I know you're here for a reason.
That's right. I've got House Bill 538. Thank you for allowing me to present this bill, Mr. Chair, members of the committee. This bill would remove the civil statute of limitations for children under the age of 18 who have been sexually abused by a person of authority. This bill is about accountability and justice. Child sex abuse is running rampant in our country. In 2024, the CDC estimated that 1 in 4 girls and 1 in 13 boys are estimated to experience child sex abuse. And child sex abuse victims, on average, don't come forward until age 52. That's why this bill is so important. That means that children now could be being educated, coached, and mentored by people who were abusing kids up to 40 years ago. And due to the current SOL, no one knows about these people. Mr. Chair and members, this bill isn't just about justice for past victims of sex abuse. This is about preventing future victims at a time when abuse of this nature is happening at a higher rate than ever before. This change ensures that offenders cannot avoid accountability just because time has passed. Parents are often not informed about child sex predators in schools, sports, camps, and churches because victims are not being allowed to go to court. It's time to remove this barrier for victims seeking justice in Virginia so that parents can protect their kids. As of now, 20 states and the federal government have eliminated the civil statute of limitations for some or all of child sex abuse claims, and I urge you to make Virginia the next state that steps up to demand justice and accountability in these tragic and life-altering cases. Thank you, and I'll answer questions.
All right. I got a question for counsel. What is the current statute of limitations for sexual abuse of a minor?
Sure, Mr. Chair. So it's 20 years after accrual, and that's defined in a separate section in 801-249. So that would say that for any sex abuse that occurs when you're a minor, it's the later of either the removal of the disability, so when the child turns 18, or when the fact of the injury and its causal connection to the sexual abuse is first communicated to the person by a licensed physician, psychologist, or clinical psychologist. So extends it quite a bit. If someone were to go to a psychologist when they were 50, let's say, and they realize that they've been suffering because of the harm when they were a child, they could file suit then.
Okay, so essentially it's 20 years from when they learn about it. So we and functionally, we have a very, very long statute of limitations for these kinds of cases as it exists under existing Virginia law.
Yes, that's correct, Mr. Chair.
All right. And then the term infancy, you said when they were a minor, this new language in italics is during the infancy. Do we use the term in the infancy? Is that normal for Virginia code?
Yes, it is. We refer to, I'm sorry, I didn't use the proper term. We use the word infancy as opposed to minor.
Okay, I just want to make sure we're talking about the same thing.
Yes.
All right, Delegate Ballard.
I'm sorry, Mr. Chairman.
Okay, Delegate Kilgore.
I just wanted to, I think what we're trying to do here is distinguish it between, I guess, to expand it to persons of authorities. Persons of authorities, that defined somewhere in the code?
Yes, sir, Mr. Chair. We added that, I think, in 2024, and you can see that in existing language on lines 55 through 56. It means a person in a position of trust having influence over the victim's life.
Delegate Keys-Gamarra.
Thank you, Mr. Chair. I wanted to ask the patron, she mentioned that a number of states have changed their laws to extend the statute of limitations. Could you give us an example of some of those states, please? I'm not asking you to read 20, but
Sure.
I would like to know where this is happening.
Yes, Mr. Chair, I would answer the delegate. Colorado, Connecticut, Florida, Hawaii, Kentucky, Maine, Maryland, Massachusetts, many, many more.
All right, Delegate Maldonado.
Thank you, Mr. Chair. Just speaking to the bill.
Why don't we hear from the public first? Okay. All right, is there anybody in the audience wishing to speak in favor of the bill? In the audience in person, anybody wishing to speak in opposition to the bill? And then we'll move to the folks online. I see somebody's got their hand raised. We'll make sure we get to you.
Yeah, thank you, Mr. Chairman, members of the committee. Rob Shin, representing the Doctors Company. We do have a specialty line of business that has these insurance policies for hospitals, boys and girls clubs, rehabilitation centers. To be very clear, we have no position on the bill, but they thought it was very important for me to communicate that based on what's happened in other states, when there's just a blanket removal of the statute, rates will go up pretty significantly. You know, some like hospitals will have to absorb the costs, but a lot of the smaller rehabilitation centers, things like that, might struggle. We may have to leave the market too, just because, you know, it's just so uncertain what the cost could be. So again, no position on the bill, but thought it was important just to put that out there.
Thank you, Mr. Shin. All right, online, I see we have Ann Kraft. Ooh, the last name is cut off here. Let me see it on my list. And Ann Tatus, Ms. Tatus. You turn on your camera, that would be fantastic. You are.
So, as the person who brought this bill forward, can I clarify and then comment?
You can comment, your comments are unlimited. You can say whatever you'd like.
Okay, great. I'm not limited to a minute. I wanted to clarify
I'm sorry.
that when you talk about
Go ahead. Take as much time as you need.
the code was read incorrectly because sexual battery, which is 18.2-67.4, that includes all molestation. That's a misdemeanor. The statutes of limitation in Virginia are separated by felony and misdemeanor. When it is a misdemeanor, when you reach the age of majority or infancy or the debilitation has ended, it is 1 year unless it is 3 years or greater, and then it is 5 years. So it's unlimited when it's a felony, but all molestation, and that's 18.2-67.4 sexual battery, and you can go through 18.2-67.4 linked to that for the definitions, we're talking about all molestation of children. So we're not just talking about rape, statutory rape, carnal knowledge, none of that. Is that there's many sexual abuse of children under 15. That is a misdemeanor. So that is not included in any of this. And that's a very different conversation. You can't blanket all of these child sex abuse as one thing. It's not. They're all separate, and they all have separate felony, misdemeanor, and what comes along with those regarding the statute of limitations. And as a survivor of child sex abuse from 6 to 10 who was not raped, my parents did not protect me. I went to them at 10 years old. So when I decided at 25 to hold my family member accountable because my family did not, I could not. And the long lasting and what we're doing to children, to the gentleman who just spoke about the interest of a hospital and the cost, is what is appalling to me, is that you put a cost above protecting children. Currently, the amount of children that are abused in this state has, in the last 4 years, just in public schools, has increased by 300%. And is that if you want to decrease the victimization of children, you protect them and you commit to protect them. They don't have a voice. They can't be here voting. It is up to us. Statutes of limitations were created centuries ago to promote fairness and assuming that evidence grows stale, witnesses disappear, and memories fade with time. But child sex abuse is not a breach of contract or a car accident case. These are unique and devastating harms against children. Survivors often cannot speak for decades, silenced by trauma, shame, and fear. Many carry their painful shame to their grave. Under strict statutes of limitations, survivors are told, "You're too late." The courthouse doors close not because the abuse did not happen, but because the arbitrary time limit has passed. Institutions know this, and they lobby fiercely to keep statutes of limitations short, because every expired clock means fewer lawsuits and greater cover-ups. The Child Victims Act in New York State allowed Virginia Guthrie to file a civil lawsuit against Prince Andrew under its revival law. And currently in U.S. Congress, under H.R. 5560, led by the leadership of Representative Subramaniam, excuse my pronunciation, of Virginia, is currently leading this legislation to make changes to the statutes of limitations in favor of children in Congress, and that has already been in there. So the question is, who are we protecting, the institutions or the child? Because the amount of children that come forward falsely, that research, I can send any of you whatever you would like if you would like to defer this. It's around 2%. Children don't have the prefrontal cognitive ability. And to penalize adults because they're shamed, or in this society, when you see headlines that say adult having a relationship or in an affair with a 14-year-old, a child is not responsible to know if they are being victimized in a society that has completely accepted the terminology that adults can have relationships or affairs with 14-year-olds. And that's why I asked to speak as the person who requested this bill to be brought forward. Because if you can sit up there as our elected duty-bearing civil servants and recite codes without people there to correctly rebut you, then that's why this stuff just gets glanced over like we're making a big deal out of nothing. Because like she said, we are one of the only states who has done nothing to protect our children with any meaningful manner in the last 10 years.
Thank you, ma'am. I appreciate it. I just really want to be clear about
Thank you.
This bill is about the civil, it's the statute of limitations for civil actions, not for misdemeanors or felonies. It's slightly different issues. And we do, again, I understand and appreciate your testimony. I'm glad to have you here. And that's why we like to have public testimony. It's not meant to be done in a sterile way without the folks that have a stake in it. So I appreciate your willingness to come forward. I know it can't be easy to put yourself out there. So thank you for doing this. All right, we also have online Shamgar had signed up, and we have a Ms. Deanna Lester had signed up to speak. Okay. All right, I don't see those folks online. Oh, sorry, there she is. Sorry about that. Ms. Lester.
Good afternoon. My name is Deanna Lester. I'm here in support of House Bill 538 from both a personal and public safety perspective. I'm a paramedic and a survivor of child sexual abuse. I provided further written comment, but wanted to put a face to that testimony. Existing legislation allowed my abuser to be removed early from the sex offender registry, creating a dangerous gap in community protection. As a first responder, I'm trained to assess risk and act when systems fail. From that perspective, I knew that gap put children at risk. I cooperated with law enforcement, including undercover work, not only as a survivor, but as someone responsible for public safety. Because of that cooperation, he is now back on the registry as a level 3 offender for life. Trauma does not follow a timetable, and public safety should not depend on one. Delayed reporting is the norm and not the exception. This legislation is not about retroactive punishment. It's about truth, accountability, and prevention. When institutions know they can no longer rely on time to shield them from responsibility, they're more likely to act decisively to protect children in the present. House Bill 538 closes a gap that silences survivors and weakens protections for children. I respectfully urge you to advance this bill. Thank you all for your time.
All right, thank you. Thank you again for testifying. Appreciate that. All right, do we have any other questions from members of the committee? Delegate Ballard.
Mr. Chairman, I think question for council. If I understood you correctly, I want to make sure my understanding is correct. You said the statute of limitations now is, I think, a max of 20 years, or when they communicate that to like a therapist or a mental health professional, but it has the 20-year max on it.
Yes, so Mr. Chair, the way it works is there's there's two options. So it's either when you turn 18, it's 20 years from then. But in a sense, it's extended, because if you turn 39 and you have depression and the doctor says you're depressed because of what happened to you when you were 16, then the 20 years would start then. It's the latter of, yes.
That's a different story. Mr. Chairman, follow-up question for council. And then so this bill obviously eliminates all of that, and you could file a personal injury action at age 85, 90, whenever.
Correct. For the person, what's the person of authority, against a person of authority, correct.
Okay, and last follow-up, Mr.
Delegates Ballard.
And this doesn't change tolling it for persons that are a disability.
Correct.
Right, so you could be under disability to age 80, and if your disability is lifted, then you still could file after that.
That's correct. The disability tolling applies across the board.
All right. Delegate Keys-Gamarra.
Yes, this is for council. I'm wondering, the statute refers to a person of authority, and we had some testimony earlier concerning what happens in hospitals and the medical field. Can you give me an idea of who's included in that definition?
Mr. Chair, Delegate Keys-Gamarra, I think that would just kind of be the eye of the beholder. So it's defined as a position of trust, having influence over the victim's life. So there's some subjectivity there. I think that probably the goal was maybe priests, teachers, but I can't really speculate on the full list of it.
Thank you.
All right. Any other questions from members of the subcommittee? All right. Committee operates by motion. It's been moved and seconded the bill report. Before we take that vote again, I understand very well what you're trying to do, and I'm supportive of it. I still have a little bit of question about a person of authority and how we're going to define that, and how it also would interplay with the different accrual methods that we have and things like that. So like Delegate Leftwich and Delegate Ballard did on a couple bills, I'm going to throw up a red light just to make sure we're not going too fast on this and haven't thought through all the potential unintended consequences. I don't expect anybody to necessarily follow me on that, because I know it's a very sensitive topic. But I'd be more concerned just honestly that we get this right than anything else. So with that, the clerk can open the roll. The clerk will close the roll. Bill report 7-2. Thank you, Delegate Hamilton. Thank you for bringing this difficult bill. Delegate Maldonado, you've got a bill. Delegate Maldonado, you've got House Bill 671.
Yes, thank you, Mr. Chair. Thank you, members of the committee. HB 671 would prohibit the exclusion of individuals with disability from jury service on the basis of disability, and it will require any determination of competency be made only after reasonable accommodations have been provided. In Virginia alone, more than 1.4 million people live with a differing ability, and yet many can still be disqualified from juries solely because of that disability. So what we're trying to do and why we care is because representation matters. Juries are supposed to reflect their communities, and in this way, trust in the judicial system is built. A juror's perspective should not be disqualified solely based on disability if they can receive reasonable accommodations and still be of service. The bill supports disabled Virginians' voices, providing the Commonwealth's commitment to a fair and representative government. And this bill allows an exemption for anyone with a disability that significantly impairs their ability to serve on a jury. And the protection lets disabled Virginians serve if they can, and they are excused if they can't. It also does not prevent any strikes in voir dire for attorneys who wish to, influence the makeup of the jury, but it opens the door and allows for appropriate consideration. So this bill supports independence and trust in disabled Virginians' voices. The protection for disabled Virginians is overdue, and disabled Virginians should feel empowered to participate in the judicial system of our Commonwealth, and this bill supports our goals: independence, representation, and access. Thank you.
Thank you, Delegate Maldonado. And we talked about this earlier. I just would note on line 58, the last section of your bill is a person with a disability as defined or described in the Americans with Disability Act. Elsewhere in 8.01, we actually use a sort of state-specific adaptation, which is very, very similar to the Americans with Disabilities Act, which is 8.01, let me make sure I'm getting the right thing, 801-2. And so if you consider that a friendly amendment that we change the references to the Americans with Disabilities Act, the federal act, to Virginia Code 8.01-2.
Yes, Mr. Chair, I would accept that friendly amendment.
All right.
So moved.
It's been moved and seconded. As many as heard that motion will say aye. Opposed? That's just keeping the code clean and consistent. So thank you for that. All right. Any substantive questions for the patron about this bill? So it seems pretty straightforward. Anyone in the audience wishing to speak in favor of the bill? Anyone wishing to speak in opposition? Anyone online? All right. Committee operates by motion. Second. It's been moved and seconded that the bill report. Clerk will open the roll. You can come on back. I can vote for you. That bill reports 10-0. Thank you, Delegate Maldonado. Delegate Carnegie, welcome to the Civil Subcommittee. It's a Chesapeake delegation sticking together there. Delegate Carnegie, which one do you want to do first? You've got two. I'll let you
I can
pick.
do 306 first.
All right, House Bill 306.
Mr. Chair, members of the subcommittee, House Bill 306 ensures that all family exempt property and homestead allowance claims can be filed without.
Delegate Carnegie?
Yes.
Move we adopt the substitute. Second.
It's been moved and seconded that we adopt the substitute that's been laid before us. As many as favor that motion will say aye. Aye. Those opposed? The substitute is now before us. Now you can speak to the bill. It's properly before us.
Thank you. Thank you.
You can call me Your Honor. That's great.
I was about to call you Your Honor.
I don't deserve it.
Thank you, Mr. Chair. And what the substitute does is provides a carve-out for real estate transactions that happen more than a year after someone has passed away. And so what this bill does is right now family exempt property and homestead allowance claims are important parts of settling estates in Virginia. However, under the current law, these claims must be filed within 1 year from the date of death. In many instances, an estate is not open. I have even had situations where I can't get an appointment to qualify for up to 9 months to 12 months. And so when that happens, the full scope of an estate's not known until 1 year after the date of death has passed. This precludes family members from making these valid claims. These claims are some of, if not only, the only matters that use the date of death as a trigger for the statute of limitations. With the amendments, this bill will begin the 1 year deadline upon filing of a will or the appointment of a personal representative. The filing of a will or appointment of an administrator will also trigger notification requirements to ensure those with rights involving the estate know that actions are occurring. This will allow for family members to make meritorious claims in a reasonable amount of time, but avoid situations where the 1 year from date of death trigger needlessly forecloses those claims. It will also align these small but important claims with other claims deadlines. And so, members of the committee, Mr. Chair, I would ask that you report this bill.
All right, thank you. And again, the substitute does adds a sentence that looks at the end to say that when title of real estate has been passed to a bona fide purchaser without notice, that doesn't affect the sale. So the real estate will be protected. You can't go back and try and rescind a transaction that happened, and that'll help save, frankly, a lot of money for home buyers and special risk premiums on title insurance if we had to insure over that potential risk that we were extending out for a longer period of time.
Correct.
Right. Any members of the subcommittee? Delegate Sullivan.
I have a question. On the sentence you were just mentioning, Mr. Chair, Why is that extended only to 1 year after the decedent's death as opposed to 1 year after the filing of the will or the appointment of administrator?
So right now in Virginia, real estate drops like a rock directly to the heirs when someone passes away unless it needs to be brought in to satisfy estate debt. And so you have that 1 year period where if the real estate is sold, you can post an indemnity bond. And after that, technically the creditor period has passed. And so the real estate is free and clear. If for some reason we allow the real estate to be subject to that claims, it would hold up the estate's ability to sell that real estate. And so the real estate would basically be locked until someone qualifies. And right now, there's many estates where people don't need to qualify if there's just real estate.
Thank you.
All right. That's a better answer than I would have given, so I'm glad I let you answer. Anyone else have a question from the subcommittee? All right, anybody in the audience wishing to speak in favor of the bill?
Mr. Chair, members of the subcommittee, Eric Link from Hutton, representing the Virginia Bar Association. We thank Delegate Carnegie for carrying this bill. It's a recommendation of the Wills, Trust, and Estates section, and we hope you'll support it.
All right. Anyone wishing to speak in opposition to the bill? All right, seeing none, the committee operates by motion.
Move to report. Second.
It's been moved and seconded the bill report with substitute. The clerk will open the roll. The clerk, Delegate Carnegie, I presume you want to vote for your own bill. That's fine. We can.
I do.
All right, we'll have you recorded as voting yes. That's fine. You don't have to run around. The bill reports by a vote of 10-0. Thank you, Delegate Carnegie. Very good. All right, now you have another easy bill.
Yes, thank you, Mr. Chair, members of the committee. House Bill 307 creates an optional streamlined process for notifying a decedent's unknown unsecured heirs and creditors with disputed claims, thereby making it easier to collect and adjudicate claims against the decedent's estate. It also provides protection for personal representatives who act in good faith to notify unknown creditors, even if an unknown creditor later arises. Right now, the process for notifying potential creditors with claims against a decedent is cumbersome and protracted. Personal representatives could even face personal liability if they distribute assets in good faith, but an unknown creditor later appears. This problem is particularly common in situations where the personal representative is not a family member or beneficiary of the estate and may not be familiar with the decedent's financial matters, which is becoming more common given the increased number of solo agers in Virginia. This bill creates an optional streamlined process for providing public notice that claims against the estate are due and for notifying known creditors in writing that disputed claims are due. The representative will then have to present proof of notification to the court. If the representative follows this procedure, they are protected against personal liabilities for claims of non-notice by a creditor to the extent that personal representative has acted in good faith to comply with the proposed bill and proceeds to distribute the assets to the beneficiaries or heirs at law. I am currently licensed in Virginia and North Carolina, and I can tell you this is the standard practice in North Carolina. Every estate that comes through, we have to publish notice to the creditors and prove that we gave them 90 days to respond. Right now, Virginia has 1 year notice to creditors, and so if you aren't a member of the family and not familiar with the debts of the decedents, then you're hesitant to distribute before that 1 year, and if that creditor should have been known, you can still be held personally liable after that 1 year.
Any questions for the bill's patron from members of the subcommittee? Anyone wishing to speak in favor of the bill?
Mr. Chair, members of the subcommittee, Eric Link again. Again, we thank Delegate Carnegie for carrying the bill as another recommendation of the Wills, Trust, and Estates section. We hope you'll support it.
All right. Anyone wishing to speak in opposition to the bill, please come forward. Seeing none, no one's signed up to speak to this one online. The committee operates by motion.
Move the report. Second.
Seconded by Delegate Lefwich, the fellow member of the Chesapeake delegation. Moved by Delegate Sullivan, seconded by Delegate Lefwich. The clerk will open the roll. Members will cast their votes.
Chair. Mr. Chair, that's my CPA, so. I want a refund this year.
Rule 69. The clerk will close the roll. Bill reports 10-0. All right. Thank you, Delegate Carnegie. All right. Who else has bills here? Is it just me?
That's a Rule 69 there?
What's that? Was she here?
Got two bills.
Casey, just lead with the recommendation of the wills and trusts. Cool. Right. Let's do the first. Let's do 133 first.
Got too much paper, no cheat sheets. Okay, Delegate Simon, you have a substitute? I do have a substitute for House Bill 133. I can move it.
Is there a motion on the substitute? You want to move it?
I move the adoption of the substitute.
There's a motion to accept, properly seconded. All in favor? Aye. Any opposed? Substitutes before us.
Thank you, Mr. Chairman, members of the subcommittee. What this bill would allow is for folks to make advanced medical directives and wills by electronic and refusals to make them and so forth by electronic means. So essentially, right now in Virginia, you can notarize almost anything electronically by a remote online notary. You can execute deeds of trust, deeds. You can mortgage your property, like I said, for $1 million and do all that electronically. What this bill would do, with certain advanced medical directives and wills and estates, we still have a requirement for an in-person signing and in-person witnesses to be there. And so what this bill does or attempts to do is to modernize the execution of these types of documents as well, bring us into the 21st century here, 26 years on, and allow for electronic attestation and signature and formalizing of these documents. The substitute is before us, and it makes some changes to make this bill consistent with the bill that passed out of this committee, I want to say in 2022, or was it 2021, right? The substitute, 2021, right? So this is a bill that we've seen before in its current form with the substitute that you guys just adopted. It's identical to a bill that passed out of this subcommittee in 2021. Similar bill passed out of this committee and full committee and passed the House last year, only to die a fiery death, as it's been described to me in the Senate. So that's a problem we'll have to deal with when we get there. This continues to have safeguards. It continues to require authentication. You need to know that you're dealing with the person who's actually the person signing it. You still have an opportunity to have a live in-person video session. So it's not like a DocuSign, or if you guys have signed things with Adobe Sign where it comes to your email box, you click yes, and all of a sudden your signature just populates the whole thing and you're done. That's not the process we're talking about here. We're talking about a live, remote, online situation where you have an opportunity to see the person, talk to the person, talk to them, have questions and answers with the live person that will allow you to, if you're a practitioner, to ascertain their capacity to make a will, to see them, hear them, make sure that the will expresses their wishes, whatever your practice is in your law practice of So whatever colloquy you go through with somebody to make sure that you know you're comfortable with that, all that can happen. It happens on a remote basis. You know, the question comes up, it came up in the Senate, what happens if somebody's standing just off camera? Let's see. So now you can't see me anymore on the screen. Somebody just off camera's got a gun to their head, right? And say, hey, you sign this thing or else. And that seems to be the scenario that they're mostly concerned with over there. To that, I respond that that's not unique to electronically executed documents, right? It's a new form, I guess, of coercion and duress that could be applied, but it's no different than somebody sitting in the parking lot who just dropped off their elderly parent or ward and said, if you don't come back with this thing signed and notarized, you know, we're not going to feed you this week, or we're going to do whatever we're going to do to you. I mean, that duress can exist out of the sight or out of the vision of the person who's executing the will as it currently stands. And so I don't know that that's a particularly unique danger to electronic will. So instead of arguing against the problem that hasn't come up here, I'll stop talking and happy to answer any questions you have. And I know we have some folks who are happy to speak on this bill as well.
Are there any members of the committee with questions for Delegate Simon? Silence. Anyone in? Delegate Carnegie, sorry.
So the testator would be on camera and both witnesses with the notary?
I don't, do we have a?
I don't think the witnesses have to be in the room.
Mr. Chairman and Delegate Carnegie, I'm going to defer to.
No, sure. So I believe, Mr. Chair, Delegate Carnegie, that you would want to look on page 17 of the substitute. The new section that we added, 64.2-462, talks about the execution process. And so it does say that it needs to be signed in the physical or electronic presence of the testator by at least 2 competent witnesses, each of whom is a resident of a state and physically located in that state at the time of signing. So it does allow for physical or electronic presence.
So the witnesses do not have to be in the same room.
Correct.
As the testator.
Correct.
Okay.
Thank you.
Any other questions for Delegate Simon? Is there anyone in the audience wishing to testify in favor of HB 133?
Mr. Chairman, my name is Dylan Bishop. I'm a partner at the law firm of Wilcox and Savage and Senior Vice President at their consulting arm. Here on behalf of MetLife today, thank the chairman for his patronage of this bill. As Delegate Simon said, the same legal precedents would be in place with regard to competence, duress, et cetera. But the purpose of this bill is to decrease the cost and increase access to these critical legal services. And we hope that this body will be similarly inclined to the 2024 General Assembly that passed this, a substantially similar measure out 100-0. Thank you.
Mr. Bishop, do you know how many other states have adopted this uniform? Maybe council knows.
Mr. Chairman, there's at least 10 states with a number of other jurisdictions and 3 or 4 other states that do permit this. And I think there's some other folks.
Can anyone tell us which ones? Always seems to be important to people as to whether they're California.
Mr. Chairman, Chris Nolan, on behalf of the Uniform Law Commission, Virginia Commissioner, there are 8 of us. I'm the chair of the delegation to the Uniform Law Commission. And some of the states that have enacted this looks to be Utah, Colorado, Oklahoma, Missouri, Idaho, Washington State, District of Columbia, Michigan, North Dakota, and U.S. Virgin Islands. It is pending in Virginia, North Carolina, Pennsylvania, and New Jersey currently.
Thank you. Sir. I don't want anyone to misinterpret my comments. I think I actually am part of the history of this bill. I think I may have brought it 6 years ago.
So, Mr. Chairman, this bill first came to this subcommittee at least 10 years ago as a nascent idea of a company that provided these online will services. And this committee said, you know, this really should be a uniform law. And for those of you who don't know, that process entails a year of study and then 2 years of drafting and soliciting comments from practitioners. And then it's subject to 2 readings in front of 400 lawyers, judges, and legislators who can get up at any time and challenge any word that is on that page because it is read line by line. And that was the process in which this was developed. You then carried it in the pandemic session that was virtual.
I think Mr. Needler was involved in that.
He did. Yes, he was. And he was the chair of the delegation at that time. And then Delegate Martinez carried it in 2024. Each time each of those two times, it passed this committee, I believe unanimously, and the floor unanimously. And as the delegate said, there are a couple of members of the Senate who may have a different view, and we're hoping to convince them otherwise this time around. So,
Delegate Simon, you're just the guy to finish the job here.
We'll see, I might draw some red votes in the House.
I think there's one other witness. Yes, sir.
Afternoon, Mr. Chairman. Jared Calpe with AARP Virginia. We also support the bill. Not enough people have wills. It can cause problems when people pass away intestate, and so making it more accessible and cheaper for people, particularly people from low-income communities who are less likely to have them, is really important. And so for all the reasons stated, including the fact that the Senate doesn't like it, but you all have passed it unanimously, we support the bill.
Great. Is anyone here to testify against the bill? Ma'am, are you trying to testify, ma'am?
No, I'm sorry. My L5.
Familiar with that problem. I'm familiar with that problem. Okay. Any other comments? Delegate Simon, you want the last word? Oh, there's one online. I'm sorry. Thank you. There is someone online, ma'am. You want to testify in favor of the bill or against the bill? You're the only one online, so whichever way you're going to testify, go ahead.
I wasn't sure I was the only one. Thank you. It looked like someone else was in the room. Thank you. I want to testify in favor of the bill. Thank you for the opportunity to testify today. My name is Kate Teal. I'm Associate General Product Counsel at Trust and Will and previously served as an estate planning attorney for just over 20 years. Trust and Will has customers in all 50 states, serving underrepresented communities, as well as those who have limited access, perhaps in rural areas, to legal services, as well as military families stationed overseas. This bill would allow the use of electronic wills in Virginia. And this is important because, as one of the other proponents noted, only about 1/3 of Americans have wills. And one of the reasons for this is the lack of access, both to affordable services and also processes that are workable and understandable for everyday families. This bill would reduce those barriers. It allows a will creation process that is more affordable and convenient while preserving the execution formalities already codified in Virginia law. As noted before, there are 16 jurisdictions who have enacted this bill, and that includes nearby states and including the District of Columbia, Maryland, New York, and Illinois are ones that I would like to call out. And House Bill 133 would allow Virginia to keep pace with these states and to also modernize that estate planning framework. For these reasons, I respectfully urge your support of House Bill 133. Thank you.
There's something particularly appropriate about having someone testify remotely about this bill. There's no one off camera forcing you to say what you're saying, is there?
There's not. Thank you for checking, though.
Delegate Simon.
Twice.
Delegate Simon, you have the last word.
No, I think for all the reasons stated, I probably can't improve on them. I hope to be the pleasure of the committee to move this one forward.
We act by motion.
With substitute.
Do we have a second? Waiting. We do have a second. Move to report the substitute properly second. Bills before us. Clerk, please open the roll. Members, please record your votes.
I vote yes.
Delegate Simon, you're heading in the right direction by a vote of 10-0.
All right. That was my hard one. Now I got an easy one.
Delegate Simon, HB 449. Is there a substitute? There is.
Yeah, I move the committee adopt the substitute.
There's a substitute. Motion to accept substitute properly second. All in favor?
Aye.
Any opposed? The substitute is before us. Delegate Simon.
All right. So, Mr. Chairman, members of the committee, we've seen this bill before, but this with the substitute is different. So what I'm going to do is focus a little bit on the differences first. Then I'm happy to take some friendly or hostile questions and see where that goes. And then I will say that I do have a hard stop at 3:30. I've been called to the Speaker's office at 3:30. So if it goes longer than that, we'll have to take it by. But hopefully we can finish it that quickly. So Virginia is now, there's 2 states left in the country that do not have a state level class action process where multiple plaintiffs can get together, pool their resources, and have access to the courts as a group and form a class, us and Mississippi. So those are the two that are left. This bill would hopefully leave Mississippi as the lone island and not allowing consumers the opportunity to combine their claims and go to court for class action. The substitute before you essentially, and it's not to say we're stuck with this, but the Senate did act on this earlier, and so just in the interest of sort of keeping things together, there were a number of concessions that were made for stakeholders in the Senate. We've incorporated all the Senate amendments into the substitute that's before you, and that's why it is what it is. Obviously, we are our own body, and we can have our own opinions, and things can change from here going forward, but I thought as a starting point, it'd be good to start with what the Senate had already done. And again, a lot of the changes in this bill were in response to some of the folks that you'll hear from that had an interest in wanting some changes to what was introduced. I'll just sort of bring you in on the things that are less consensus oriented. First thing we do is we bring in the Virginia Consumer Protection Act specifically as a statute that can be the subject of a class action claim. And I was just looking at that. What page is that on? That's on
Page 8.
Page 8, second to last page. Yeah, you'll see that starting at line 188? Is that where we bring in 59.1? Yeah. So 59.1 is the Consumer Protection Act. On lines 190 and 192, you'll see that we add the language per violation. So whenever there's an action, you're not limited to just your actual damages or $500 per violation. And then for willful violations, it's $1,000 per violation, or the actual damages, whichever is greater. And then on lines 208 through 210, we add language that says that you're not required to prove that the person bringing the claim relied on the prohibited practice or representation to establish that they suffered the loss. So in other words, the Consumer Protection Act has got a lot of blanket practices that are illegal. I'm thinking of one bill that I put in years ago that says you can't, you have to give folks the opportunity. If they sign up electronically, they have to have an opportunity to opt out electronically by the same method. You don't have to, sign up with one click. You got to call and sit on hold with somebody for 3 hours to get off, right? And that's if you don't let people do that, it's a violation of the Consumer Protection Act. You don't have to say that, well, I wouldn't have bought the product if I had known that unless I had known it was going to be really easy to opt out, and they're violating my rights there, right? So the thought is, because the Consumer Protection Act covers a lot of fairly innocuous acts, it's sometimes difficult to prove that the only reason you bought this product was because, or but for this protection in the Consumer Protection Act you might not have known about, you wouldn't have bought the product, that you're somehow not damaged. So I think that's what the thought process was there. The per violation, again, is because sometimes these are things that happen in relatively small consumer transactions, but they happen over and over and over again. Being billed for something you didn't actually order, and it keeps coming on your monthly bill over and over and over again. Each time they do that, it's a new violation, even if it's a relatively small amount, because it's $1.50, $3 added to your bill that you weren't supposed to be charged. The idea is, well, it's such a small amount, they'll never sue us for it. We'll just keep doing it until somebody complains and stops us. And that's the kind of bad acts that you want to create a bar for folks doing, a real deterrent for them doing that. I know that some folks in the audience are going to say that these are harsh and unprecedented. I think the response to that is don't violate the law and don't rip people off. You don't have to worry about how often these things happen. The rest of it, again, mostly mirrors what's in the federal system. I will note that there is another area where we go a little bit beyond what's in the federal system as far as the list of things that are considerations. And there's a list of 4 somewhere that has 5. Oh, here it is. Oh, sorry. I had a lot of bills to think about today. Anyway, I think that's about it for my presentation. I can stop talking now and answer questions.
Thank you, Delegate Simon. Are there any questions for Delegate Simon from members of the panel? I've got Delegate Keys-Gamarra first in line.
Thank you, Mr. Chair. I have not been able to go over the substitute thoroughly, but is there
I haven't been able to go over the substitute thoroughly, but is a section in here that allows for claims related to actions prior to the effective date of the statute still in this bill?
Yeah, so
if so, would you explain that, please? Thank you.
So I think it's in the on line 215, provisions of this act, starting on line 214, the provisions of this act are procedural in nature and shall become effective July 1st, 2027. Any conduct occurring prior to 2027 might be filed as a class action, provided that such conduct is otherwise actionable pursuant to relevant law. So this bill, yeah, that's on the last page. It's in the enactment clause, and essentially we're not making any new activity. We had a lot of conversation right about ex post facto law on the floor lately. But we're not making any activity or action that wasn't illegal prior to July 1st, 2027, illegal with this bill, right? Everything that you're doing, everything you can sue for are things you ought not have been doing prior to the effective date of the class action remedy, right? We're really just talking about a remedy here. So that's the reason. Normally we make things like this bills prospective, right? In terms of this act will only be true going forward. But again, if you've been conducting a prohibited practice under the Consumer Protection Act, for instance, since 2022, you shouldn't have been doing it in 2022, you shouldn't have been doing it in 2023, you shouldn't have been doing it in 2024. You could have been held to account for it in any of those years anyway, but you would have had to be held to account by one individual bringing their lawsuit, one lawsuit at a time. So that's the reason for not necessarily allowing this to have, I wouldn't say retroactive application, but being explicit, right? Because this is just a new remedy for existing violations of law, that there was no need to make it only effective prospectively.
Follow up, Mr. Chair.
Delegate Keys-Gamarra, go ahead.
Yes, and so two-part question. How far back can that go, and would these claims as here be affected by the per occurrence limitation you mentioned? I think it's on line 190.
Yeah, so I mean, the existing statute of limitations would limit your cause of action, right? So yeah, so whatever the cause of action is for that particular misdeed, that's the protection for the I would say tortfeasor or whatever you want to call them. I guess tortfeasor is probably the right word. The person who's doing the bad thing is, if the last time they did it to you has been 10 years ago and this has a 5-year statute of limitations, you can't go back. This is only a new remedy for things that would have otherwise been within your statute of limitations.
Mr. Chairman.
Delegate Kilgore.
I see a lot of these class actions, and I think most of us have gotten, notices that we're included in a class action. I look through it and I say, I get some coupon, but the lawyers get $14 million. And I'm just trying to figure, would your bill allow the lawyers to make all this money and me get a coupon?
Mr. Chairman, there's, there are certainly some criticisms of class action as a remedy, right? And I've heard those, and I took a law school with my father's mentor, Ralph Nader. He offered some alternatives to class action, something called cypre, right, where they should do some sort of public good in addition to whatever individual remedy you've got. And that would be another bill. First, I think we need to have the remedy of class actions. I agree with you that in many cases, it's not a perfect remedy. I think it's better than, again, what's available now without a class action. But I'd also be supportive of adding some other things that you could require tortfeasors to do that would have a greater impact on the folks that have been affected than just the coupon for $1.50 off their services. They've been ripping you off forever anyway.
Delegate Ballard.
Thank you, Mr. Chairman. Chair Simon, so as you probably know, one of the reasons I opposed this in the past was the summary judgment issue. So this bill, again, doesn't really do anything to add summary judgment to the process. And so still in Virginia, if we would allow for this class action bill to move forward, there still would not be any summary judgment to, I guess, combat against it on the other side. Is that fair?
Well, you'd have an opportunity to get summary judgment on the inability to establish you've got a class that fits the definition, and this is a remedy for them. That part could get thrown out pretty quick, but you'd still have to go through, just like you do in Virginia on any civil suit. You couldn't do it once you got to depositions on just the written evidence. You'd still have to get further on through the process.
Well, let's let the audience weigh in. I have some comments. They're not really questions, so I'll talk later. Is there anyone in the audience?
Tried to anticipate your questions, Mr. Chair.
Let's talk in favor of this bill. Yes, sir.
Mr. Chair, members of the committee, good afternoon. Elliot Buckner on behalf of the Virginia Trial Lawyers Association in support of the bill. Thank you.
Thank you, sir. Yes, ma'am.
Mr. Chair, members of the committee, I'm Joanna Darkus here on behalf of the Virginia Poverty Law Center. We wholeheartedly support this bill urge you, like your colleagues, to support it once again, get it to the governor's desk and across the finish line. Virginia needs to get off that short list with Mississippi. They need to get off the list too, that doesn't allow this remedy. That's really important. It promotes judicial efficiency. It promotes actually getting relief to people who've been harmed in similar ways by companies that currently can get off without making everyone whole, simply because we don't have a good mechanism to allow them to do that. As a provider of legal services across the Commonwealth, as someone who's speaking for the legal aid community, we know just how scarce judicial resources are and how scarce legal resources are. So this is a really efficient mechanism for actually making sure that there's access to justice and that businesses who follow Virginia law, who don't rip people off, are not at a disadvantage when they're businesses that get away with doing just that. So urge you to report this bill. Thank you so much.
Thank you, ma'am. Is there anyone in the audience who wants to testify against the bill?
Good afternoon, Mr. Chairman, members of the committee. Appreciate your time today and thank the patron for working with us on several amendments already that I'll mention that I think are helpful. I've said this to the patron and several of you. The Virginia business community has long viewed the absence of class action lawsuits as a badge of honor and a real positive for our legal climate. It is our view that the relative advantage to the individual members of the class, as Delegate Kilgore mentioned, don't outweigh the burden on the businesses having to defend. Sometimes there may be good claims, sometimes there may be less good claims. And again, I think we have always viewed that as a good reason not to do it at the state level. I understand the trial bar and some of the advocacy groups have a different view, and I understand why. But my initial advocacy to all of you would be for us to remain exceptional on this point. And not go down this particular path. That said, this is a policy decision for the General Assembly, and there's been an interest in proceeding in the past, and I would have my secondary piece of advocacy be, if you are to move forward and go down this path, please do so judiciously on the one hand, and hew as closely as is possible to the federal rule that businesses operate pursuant to now, and the majority of other states. To that end, we appreciate the changes that you'll see in the venue section and the interlocutory appeal section. Those are good. We requested them, they were made, and we appreciate it. I think Delegate Simon covered the other ones that we are focused on. I'll draw your attention. Maybe not this one.
That's what I couldn't find.
Yeah, okay. So drawing your attention to lines 40 and 41 of the substitute. This is the section where you're figuring out if a class is appropriate. The first four Romanettes under 3, and this is B3 of this section. The first four, my understanding are identical to the federal rule. The fifth is a new one of our own creation, and I haven't spoken with advocates to know exactly where it came from, but I am reading that the practical ability of individual class members to pursue their claims without certification. I'm viewing that as a little bit of a catch-all that one could often say it's not practical for, an individual member of the class to afford me, the attorney who's putting the class together, which is very frequently how this works. This is not, in a lot of situations, it's not necessarily the members of the class who are coalescing to put the class together. It's a lawyer certifying a class to go after, and as you say, getting notice in the mail to the members of the class. So would respectfully request, if the bill is to move forward, consideration of striking that to get closer to the federal rule. To come to summary judgment in a second. And then, I think the other two I won't belabor. We would ask you to strike the per violation. The research that one of our member attorney groups has done suggests that would be a pretty extreme outlier position in the country as to class actions. I know there's a disagreement about that. There's a member of the trial bar who has done his own research who thinks it's maybe not the case, but I'm happy to provide the committee with that research. The reliance point and the retroactive point are the last two. But the summary judgment to me is the most important. All of the defense practitioners, well, let me start because we've got some new folks on the committee. We are the only state in the country that does not allow summary judgment to be based on deposition testimony for the vast majority of claims. That is an old rule. I think it came to, Ellie can probably correct me, came to fruition in the 70s. There was a particularly strong member of the trial bar who was chairman of, I think, Senate Courts Committee, and that rule has been in place ever since. No other state has it. And as a result, when you as a company are defending yourself in a piece of civil litigation in this state, you have to wait until much further in the process to kick out bad claims. That creates expense and drives up settlement values, I would suggest probably in almost every case. So the General Assembly has chipped away at that a little bit, that rule from the 70s, and a couple years ago authorized summary judgment, meaningful summary judgment on deposition testimony in business-to-business cases of over $50,000. I think at least partially under the theory that this was not, little guy versus the big company situation. It was business-to-business with sophisticated parties who can hire attorneys to handle a summary judgment motion. I would liken class actions to that situation. And in the vast majority of cases, this is not, again, a class putting itself together. This is lawyers organizing the class. They can handle a summary judgment motion. Long time ago, the argument against summary judgment, in addition, was that there was no court of appeals. We now have one. We now have one. Last point on this, I've heard it say that our courts are not set up for summary judgment because there's too many cases going on. There are no doubt too many cases going on. I don't think authorizing class actions is a way to cut down on that necessarily, although we did hear testimony in the other body from advocates saying that they were having to bring lawsuits 90 or 100 times on the same set of facts. Surely this will clear some of that up. So maybe that's the point, and then the trade-off would be meaningful summary judgment. So thank you for giving me so much time. If the bill is to move forward, we'd love to keep working with you on it. I'd love to bring up a member of the chamber to provide additional comments. Thank you.
Yes, ma'am.
Mr. Chair, members of the committee, Michelle Satterlin on behalf of Volkswagen Group of America, which is headquartered in Reston, Virginia. First off, I want to thank the chairman, Delegate Simon. He has been terrific about having an open door policy and talking about this bill, and the substitute that you have before you does reflect our amendments that we have requested, and we are grateful for that. But as Edward already laid out, there are a number of concerns still in this bill. And starting a new state class action, that is a significant change in Virginia. And so if we are moving forward, we underscore that it should reflect what the federal rules of civil procedure, specifically Rule 23, and other states do in terms of class action. For Volkswagen Group of America, we are focused on two items, and we've had some discussion already about the per violation in statutory damages. This is concerning because we don't know what that means. This creates a level of uncertainty. I know that we've heard from proponents that it's just the actual harm, but what is that harm? Does it go back? Does it go forward? Is it continuing? There's a number of questions about that, and it creates great uncertainty for business. Additionally, as has already been mentioned, is the enactment clause, the retroactive. And we don't disagree. There is a statute of limitations, but a statute of limitations on a case, a one-on-one case under the Virginia Consumer Protection Act is very different than going back retroactively with class action. So again, this is a very highly unusual step that we're not looking at prospectively, but retroactively, and I just underscore that is, again, a level of uncertainty that does not comport with business. If we move forward, as Edward has already said, we hope that we can continue the discussion, but this is a significant step, and we ask you to be thoughtful as you move forward with this bill. Thank you.
Thank you, ma'am. Yes, sir.
Mr. Chairman, Eric Link from Hutton, speaking on behalf of the American Tort Reform Association. We oppose the bill, and we'd like to associate ourselves with the previous comments.
Mr. Chairman, members of the committee, Matt Benedetti representing the Virginia Creditors Bar Association. We also associate with the comments made previously.
Mr. Chair, Elizabeth Parker with Trotman Strategies on behalf of the American Property and Casualty Insurance Association, and we ask you to oppose the bill.
Mr. Chairman, members of the committee, Matt Bruning with Virginia Bankers Association, consistent with the last, 7 years that we've seen this bill, we are opposed and associate our comments with those previously made.
Mr. Chair, members of the subcommittee, Nicole Brenner with Seven Hill Strategy Group, testifying for the Hospital Association, who is stuck down the hall on behalf of 2 of their members, also in opposition.
Thank you. I see we have some people online to testify, Mr. Clerk. 3 of them in favor. So why don't we do that? Ms. Kelly?
Thank you for having me, members of the committee. My name is Christy Kelly. I'm a resident of Fairfax County. I am on the board of Housing Opportunities Made Equal, the Legal Aid Justice Center, and I'm a lawyer in Fairfax. I'm here in support of the bill for a number of reasons. First and foremost, it is an issue of access to justice. As a former legal aid lawyer, a lot of times you see problems in the marketplace that impact low-income individuals that you can only handle on a one-off matter. And this bill would allow us to handle problems in the marketplace and deal with bad actors and get everyone relief. My law firm was referred a case from the Legal Aid Justice Center for women who had applied to a nursing school in an effort to better their lives. They went to school in the evenings, and we represented 19 immigrant women because the former Attorney General was not willing to prosecute the school, and so we had to handle that matter civilly. We had a trial in Fairfax County for these 19 women. It took a full week because all 19 of them had to testify about their damages. We obtained a favorable outcome, but only 19 women were able to get relief. There are hundreds, if not thousands, of women who were scammed by this school who was actually not licensed and took their money. And after these women attending for years, they had nothing to show for it. And so every week, my law firm gets a call from another student who was victimized, and we can't help them because we already represent 19 people. And so none of those women will ever have justice and cannot find a lawyer to help them because there aren't enough lawyers who do what we do. And so none of those women will recover and be able to get their damages for the conduct that they suffered. In addition, my firm was involved in the Volkswagen emissions cheating scandal a few years ago in Fairfax County. And there were over 400 cases that had to be done separately because people who lived in Virginia could not join together and file one case. If you lived in Maryland, you could do it. If you lived in West Virginia, you could. But because you lived in Virginia, you could not join together and file a case. And so our judges had to litigate the same issue over and over and over again every single day for more than a year. And that caused numerous problems with other matters getting resolved. Divorces were delayed, other matters that were before the court because they were busy doing the same case, the same motion over and over and over for a different individual because we did not have this procedural mechanism. Additionally, as to the comments about per violation, the courts, federal courts and Virginia state courts have already determined that the Virginia Consumer Protection Act is per violation. It is routinely litigated, and my understanding is that the bill is just to provide a clarification to minimize the burden on the courts of having to continue to litigate this issue over and over. And if the committee would like decisions, we're happy to provide them to you. And the last point I would like to make is that this is just a procedural change. And so it's not extending any statute of limitations or anything. It is just allowing this procedure to be put in place so that consumers and individuals who are being victimized by bad actors can get redress in one fell swoop and minimize the burden on the courts and the Commonwealth. Thank you.
Thank you, ma'am. There is another woman online named Victoria. I cannot see her whole name. I'm sorry. Could you introduce yourself, ma'am?
Yes, I also am at home and not used to this camera. My name is Victoria Horak, and I'm an attorney at the Legal Aid Justice Center, and we support the bill. Here, I'll hold the camera right here. I echo a lot of the comments that Christy Kelly said about this bill. I represent people in general district court, low-income tenants and low-income consumers across the Commonwealth, and especially in Central Virginia. This would be a critical tool for us in combating bad actors. The communities we serve have very limited access to justice and limited access to lawyers. And this would basically allow people with small dollar claims against in-state defendants to have the same rights that people with high dollar claims against out-of-state defendants have. Like right now, you can bring class actions based on state law in federal court, but if you're a low-income tenant against an in-state landlord, you can't do that. One example I think I want to share with everybody is like low-income tenants in a local apartment complex. They'll come into my office with illegal fees, illegal pest control fees, illegal administrative fees that sort of aren't in the lease. And I'll have the judge go to court, have the judge agree with me that those fees are unlawful. And then I'll get another tenant from the same complex coming into my office and the same fee is like on their account. There is nothing right now, no mechanism in our state procedure to hold those landlords systemically accountable for those bad actions. And not all Virginia landlords or Virginia companies do this, but the bad actors know that they can get away with it because it's very hard for these low-income individuals to come one by one into court to get justice. So this bill would allow like systemic reform for those groups. And just to a couple of the points, you know, I know that there is a lot of commentary about how this is something for the plaintiff's bar, and I can assure the committee that this is already the plaintiff's bar can go into federal court, but this is something that us as like legal aid lawyers who are lawyers for consumers and for the common good, now we can get into state court and defend our communities. So we support the bill.
Thank you. And I see Mr. Bennett is online. Mr. Bennett, welcome.
Thank you. My name is Len Bennett. My law firm, Consumer Litigation Associates, based in Newport News, Virginia. I'm members of the Board of Public Justice of the National Consumer Law Center, formerly of NCLC. I think more important in terms of my own personal ego or pride, both Ms. Kelly's firm and our firm won the Virginia State Bar's Pro Bono Awards, top law firm, not without exception. And that's been a consistent part of my practice since I quit my clerkships after law school and went into private practice, and Ms. Kelly when she left legal aid to go into private practice. And roughly a third, at least, of the lawyers that work for me have to devote that time for pro bono work. This particular bill, I'm allied with the Virginia Trial Lawyers Association. I'm a member of the organization. We have had to do work with the VTLA to make sure that it was supportive of this bill. And I don't do this. Many of you may have talked to me before, but I'm not an advocate here. But it's odd to me that when Volkswagen, on behalf of the chamber, gives a list of 10 things that they want changed, and Delegate Simons offers 8 of the 10 in a substitute, that's not enough. And I don't think anything would be enough. We're asking you to do not what the trial lawyers ask for, whatever that means. I don't do personal injury work. If trial lawyers means I represent the Seaview tenants, Delegate Thornton, you've seen it all over our press, as of our Chesapeake delegations. The Seaview tenants that Ms. Kelly, Virginia Poverty Law Center, and I represent 94 individual tenants. Newport News condemned the apartment owned by a New Jersey absent slumlord because of maintenance. We have to have those 94 individual trials. The Newport News Circuit Court, a great judge, Judge Mills, said to me, there's just no way we can handle it unless the legislature gives us 10 more judges, which of course I think I'll support Delegate Thornton to try to get him for us on the peninsula, but I don't think it's forthcoming. And as a result, the Virginia Supreme Court had to appoint a retired judge to handle those 94 tenants, and several of which have died. We've had 3 of them death notices we had to file because we couldn't get this done with the process now. You also remember the litigation that was taken against the Virginia Employment Commission because of the problems that existed with unemployment benefits. I was the lead. I was the mouth, the person, and we had to litigate in federal court on behalf of a variety of legal aid organizations in every one of your districts. And we had to go to federal court because there was no way to do it for private individuals in state court. I know that there is a Delegate Kilmore. I wholeheartedly agree with you regarding greedy attorneys that take and use their consumers for money. That's wrong. That's why we don't do that. But in the Western District of Virginia and the Eastern District of Virginia in federal court, it is not done. We take, if we seek fee at all, and often we don't, a fee that is tied completely to what our clients get. And that has meant in federal class action litigation, without exception, if the class ends up not getting much at all, and I have a huge lodestar, then that is what I'm stuck with, the percentage. And I know that this bill has passed or tied one time with Delegate Heretic still around in civil, but has otherwise passed. In fact, every single person I guess so, Delegate Simon, you voted for it. Delegate Sullivan, you voted for it. Delegate Maldonado and Reeser and Keys Gamara, and I'm sorry about names, but you've all voted for this. This bill is more conservative because it now tracks the current Rule 23. The language that the chamber suggests might be odd to ours is actually more restrictive than Rule 23, which has a superiority obligation. That's all. And this bill tracks a federal rule that is written and amended under the supervision of our current United States Supreme Court. This is why we are number 49. I'm sorry, we're number 50 because the District of Columbia has this. So we're 50th out of 51.
Counselor, I'm going to ask you to wrap up your remarks.
The last thing I'll say is this summary judgment red herring that keeps coming up in the battle between the VTLA and the chamber, that doesn't fit here because the advocate of a class has to pay for the notice in almost any instance. So the case will resolve or the case will have to have merit for anyone to advance the money and the effort and the resources for this to even be certified. So anyway, thanks for putting up with me and with this. But I ask for behalf of all the Virginians that you each represent that you support this bill.
Thank you, Mr. Bennett. Appreciate your comments. That's all that's online, right, Mr. Clerk? Okay. Back in the committee, I have some comments. Do you want to make final comments before we discuss it in committee?
Just really quickly reacting to some of the things we heard. I would say, Mr. Bennett made the point for me. Maybe it was a strategic mistake. Maybe I should have started with the original bill and then told you the 8 or 9 things that we were doing for Volkswagen, the chamber, and the others. And I appreciate, by the way, the advocates acknowledging that they'd already received some. But it's important for me to remind you that this has been a conversation and negotiation. It's not been we're in charge now, there's the bill, take it or leave it kind of a negotiation. We've been very thoughtful about what we can accept and what we can't. I think we've made a number of concessions to the concerned folks. Nothing obviously that got them to the point of standing down or supporting it, but meaningful concessions. I would say that there are a couple things that are different, and I would say that we ought to remain exceptional here in Virginia. And so it's okay that not everything's exactly the same as we do it, but I think it's well tailored to what we do. It is something that we voted for before. I know that there are some nits that folks have to pick with some of these things. I'm happy to continue the conversation with anybody who wants to keep talking about it, but I think that it's high time we had this remedy available, this procedure available for folks that are aggrieved here in Virginia.
Thank you, Delegate Simon. Let me just take Chair's prerogative and make a couple comments. We'll see if anyone else goes on the board. Those of you who've been involved in some of these conversations, a couple of things. One, I do want to thank you, Delegate Simon, other advocates for this bill, I'm aware that there have been a lot of ongoing negotiations and a lot of what I think I would describe and others would describe as progress on it. Course of my career here, I've been, I think it's fair to say, resistant to this, although Mr. Bennett is correct, I did vote for it last time. And I appreciate that the bill has gotten better and better over time, and I'm sort of the poster child for bringing bills over and over again, and they do get better over time. I believe we should get off that very short list of states. There's no reason that Virginia should not have this remedy. I'm glad, for instance, I think this is the first time that the interlocutory appeal language is in, and I think that improves the bill. I think the venue provision has been changed. I think that improves the bill. Mr. Bennett, I'll just have to respectfully disagree with you. I still believe we would be in a better position as a state, both our judiciary and our business community, if we had in place before doing this bill a federalized summary judgment process. I think it works in the federal system for good reason, and we ought to adopt it, maybe at a minimum just for these kinds of cases, the way we did for business-to-business cases before that. I will tell you, I'm troubled by the fact that this bill, I think for the first time, it did not do this last time when I voted for it, brings a whole new code section, the Virginia Consumer Protection Act, into play, and makes a really substantive change to a section that, frankly, a lot of us on this committee have ongoing concerns. I looked at it just a moment ago. It now has 87 different paragraphs, and it's sort of the classic General Assembly Christmas tree, where every year something gets added to the VCPA. And now we're essentially adding a whole new wrinkle to the VCPA, including this issue having to do with per violation. I know there's some disagreement as to what that means, but I think that's a sort of a big unknown here that sets off some red lights for me. So I will tell you that I personally, I'm speaking for myself, of course, don't like the fact that we took this opportunity to add a whole new section to this bill and incorporating the VCPA. And that leads me to another comment having to do with the fact that you are changing, this bill changes for the entire VCPA. It eliminates the need to prove reliance. And you made an interesting point, Delegate Simon, about how there may be some things where reliance would be difficult to show because the VCPA has such a broad group of things, some relating to it's all important, but it's all important to whomever's claiming under it, but big conduct, little conduct. But that's why it's called reasonable reliance. Reliance is going to be different in every single case. And I know that this bill says it right on line 220, is intended to reverse Owens v. DRS Auto Phantom Works. One of my problems with the bill is I kind of liked the result in DRS, Owens v. DRS. So that gives me pause. One last, I'll pose it just as a hypothetical question, Delegate Simon. A couple people made the point that one of the things you've done is to try to get closer to the federal statute, which I appreciate. It is the case, I've got Rule 23 up in front of me, that the list of factors the court can consider in making its findings is identical to Rule 23 until you get to the last one, which would deviate from Rule 23 in the fact that it exists in your bill but doesn't in Rule 23, and that's the, quote, practical ability of individual class members to pursue their claims without certification. And as I sit here today, I don't know what that means. I'm guessing it would be, at least potentially, the source of an awful lot of litigation. So I don't know why, if what we're trying to do is get closer to the federal statute and we lift an entire part of the rule out of it, we then added something which, as far as I know, is untried, at least that I know of, anywhere else. So that's a long speech. I'm still uncomfortable by the things I just mentioned. I would ask you hypothetically if you'd at least be interested in striking Roman at 5. If not today, at least think about it as the process unfolds. I'm going to try to stay engaged in this. I have a sense of where this bill's probably going. But I do think it could be continued. We could continue to improve it. I'm interested in our having a good class action process here in Virginia. I'm not looking at stopping the class action process. I'm looking to have a good class action process. I think we're getting really, really close, but I think there are a couple of things, in my view, you could consider.
Sure. So happy to consider a lot of them. Number 5, I would just say this argument cuts both ways, right? It's either the end of the world or it's not. But you look at the beginning of the sentence, it says, in the making of this finding, the court may consider. And it lists 5 things. So we're just giving them one more thing that they may or may not consider. It's one more thing you can argue. So I think it's sort of hard to believe that this would be the thing, the catch-all that gets all these cases that wouldn't otherwise be able to get into court. On the other hand, well, Marcus, if it's just may, why not strike it, right? I get that argument works both ways. I just don't think that one is, frankly.
Right back at you. Why'd you put it in there?
Why'd you put it in there? And I think
it's a creative bar here in Virginia.
I think there are some cases where you want to be able to at least argue, right, and have something that can be considered that it's impractical to proceed because of the size of the claim, right? It's a really small claim. Nobody's going to hire a lawyer to pursue their own individual $90, but $90 might be a lot of money to them, and if they can all get together, this would be the only way they'd ever go after that size of a remedy. Because sometimes, yes, sometimes it's a $1.50 coupon, but sometimes it's $100, $150, which is real money, but the only way to practically get it is to band together in a class. And so that's why I still think it has some value. And if I could write the federal rules, I might add that.
You said my piece, and I appreciate the committee's indulgence. I see Delegate Leftwich is on the board.
Thank you, Mr. Chair. I should know this because I've been around since this was first introduced, I think, 10 years ago, but I don't recall what the objection to summary judgment is. If you could.
So I think that the typical is we don't do it in Virginia, and I think this is not the place to start. We're trying to make things more consumer friendly, and I think that making it more difficult to get your case around the merits and would be something we wouldn't want to approach. And again, there's trying to bootstrap the whole issue of summary judgment, which we don't have anywhere else, anywhere in Virginia procedure, to the class actions is just not a horse trade that I'm willing to make on this particular bill. That's another topic for another day. But I get it's an opportunity to make it because we're doing something here, but that's, like I said, that's got a long history. We have a lot of impacts that way down the line that we may not want to touch here. And I've got about 5 minutes before I have to be upstairs.
Thank you, Mr. Chair.
Ballard.
Thank you, Mr. Chairman. Chair Simon, I'll make this quick. I echo a lot of what Delegate Sullivan said. I really don't have any opposition to creating this state class action in Virginia. That's not my hesitation, but Delegate Sullivan hit the nail on the head. I really don't understand, and Jay stole some of my thunder. I don't understand the resistance to modeling after the federal process, which you just addressed. You want to make it more consumer friendly, so I get that. And then I guess my second point was, and I think you just addressed it as well, could we not create the summary judgment process just for the class actions? And I kind of disagree with the attorney that spoke last. If the summary judgment issue is irrelevant or a red herring, then why are we so resistant to it? So not necessarily that you have to answer or respond, but I do agree with Delegate Sullivan and Delegate Leftwich on a lot of these things, because otherwise I would probably vote for this because I'm not resistant to the process. So thank you.
Delegate Keys-Gamarra.
Thank you. I really appreciate you bringing this forward, and I agree. I really want to move toward something. And part of my vote is based on the fact that, one, I think you've done a lot of work already, and I trust that you're going to move forward doing that. I hear the concerns, but I don't feel like we're in really good company right now with respect to not having this kind of access to this mechanism. So I'm going to support it, and if it's appropriate, Mr. Chair, I'll make a motion.
Not only is it appropriate, but Delegate Simon has someplace to be. So. I have a motion to report. Is there a second? And it's a substitute. Motion to report the substitute. Is there a second? I'll second. Properly seconded. No further questions or comment from the committee members. Clerk, please open the roll. We'll go on the board. Would you like to vote, Delegate Simon?
You can vote me yes. balance yourself out. All right. You're going to announce the vote?
We're running out of time. Someone once said that. The substitute reports by vote of 7-3.
Thank you, Mr. Chairman, members of the committee. And again, continue to have conversations. I'm happy to discuss this with anybody.
Mr. Chair, I am told that Delegate Doherty would like us to take her bill 364 by for the day.
All right, is there a motion to take Delegate?
So moved.
Take Delegate Doherty's bill by for the day. As many as favor of that motion will say aye. Aye. Those opposed? The motion carries, and I believe that completes our business. The committee will rise.